Hello everyone. The convergence of competition law and data protection law has been something which a lot of people have been talking about, I think, a bit for a few years now, but it's just been remarkable from our point of view how much it's crossed our desks in the last 12 months at a really practical level, which was why we thought we would talk about it today. Now, full disclosure, I'm not a competition lawyer. I don't know anything about competition, in fact, competition law. But the good news is that I don't have to, because this has been an entirely one-way street. This is about competition lawyers getting really, really interested in data protection. We are the ones with the cool, sexy law that everyone else wants to get a piece of. So, just to go through, this is my lovely Venn diagram, and I'm going to talk through just a few issues where they really are converging. So I'm going to start with the competition authorities who've been really, really interested in data protection, and particularly this idea that use, or rather misuse, of personal data could constitute an abuse of dominance and therefore be in itself a breach of competition law. Now, the real sort of player, the big player in this, the one who's been most keen on this, is the German Federal Cartel Office. Although we have seen a variety of high-profile and much more under-the-radar investigations, so this is by no means limited to Germany. The most high-profile one investigation that they've done is, has been against Meta, where they were arguing, and then indeed issued a decision, that Meta's processing of personal data, which in their view infringed the GDPR, was an abuse of dominance. Now, Meta appealed this decision, and indeed it's gone all the way up to the CJEU to ask whether, in fact, a competition authority can make a ruling on non-compliance with the GDPR. And we don't have a decision yet, but what we did get in September was a really interesting opinion from the Advocate General, and he said that no, technically speaking, a competition authority, they're a competition authority, they can't make a decision on the GDPR, but what he said was that they could incidentally decide that a company had breached the GDPR, which I think for some of us makes us a little bit uncomfortable with the idea that a competition authority that potentially doesn't really know anything about data protection law could still make a finding that just sort of incidentally you are non-compliant with this very complex area of law. Now, just an opinion at this stage, so we're all waiting. We think the CJEU decision will probably come out later on this year, and it'll be really interesting to see where that happens and whether the authorities are perhaps put a little bit back in their box. A little bit closer to home, we've got the UK Competition and Markets Authority working alongside the ICO in their review of Google's Sandbox APIs, which will be the alternative, their alternative to third-party cookies in Chrome. And it's been really interesting that one of the sort of commitments, one of the standards which the CMA has said they will judge Google by is their compliance with data protection legislation. So again, you have an example of a competition authority looking specifically at something from a data protection angle. Now, so far I've talked about the synergies between data protection and competition law. It's not actually always a match made in heaven, and there can be some real tensions, particularly since competition law can so often be about data sharing, open data, about multiple parties in an ecosystem, and that can actually conflict sometimes quite a lot with some of the GDPR principles of data minimization, purpose limitation, and privacy by design. So we have actually equally been helping some clients who are using GDPR as indeed a defense in some competition cases where they're saying, well, actually, we can't do what you're telling us to do because of GDPR. So it's not always about the two coming together. Moving on to the Competition Appeals Tribunal. Now, not everyone may know what this is. This is the UK courts specialising in competition appeals. One of the things that you can do in the CAT is that if you're a claimant who's suffered damage for breach of competition law, you can bring a claim for compensation. And the really exciting thing about it is that it's one of the, if not the only, opt-out class action regimes in the UK. And that has got some claimant law firms very excited because, as most of you probably know, as a result of Lloyd and Google, it's much harder now, if not impossible, to bring a really great class action for a lot of people in the GDPR, under the GDPR. Those claims are pretty much dead in the water. So innovative and creative people are looking for new ways to do this. And some of them think they might have struck gold with the cat on the basis that if you can argue that, well, this breach of GDPR is in fact an abuse of a dominant position, then me and the millions of other consumers in my class can suddenly do an opt-out class action in the cat. Now, the first attempt at this, which was, again, poor Meta, it's always them, isn't it, this whole topic, was actually dismissed in February, but it was dismissed on a procedural grounds, which, not being a competition lawyer, can't pretend I understood. But the gist of it is that they could try again if they sorted out their proceedings. So I think that I wouldn't write that route off yet. And lastly, I'm just going to talk very briefly about the EU Digital Markets Act. Now, the EU Digital Markets Act is going to sort of start applying in the EU as of next year, and it's a competition law. It is 100% a competition law. It is being enforced by the EU the EU Commission, and it is designed to regulate the big tech companies who are called gatekeepers under the platform. And it's all about trying to sort of regulate that the marketplace of online platforms. And it is chock filled with data protection law requirements. So it's got rules about consent for using personal data for advertising. There's provisions on data portability. There's provisions on profiling. It is, it reads in some ways like a whole new GDPR. And I thought it'd be a really good note to end on because I think it proves that this is not just a fad or a trend. This is something which is now being baked into statute. And so really is sort of, I think it's here to stay. I think it's the long term. So you might find that if you have any colleagues who do competition law, they're going to be sidling up to you and trying to be your best mate because they're going to want to understand what all of this is about. And with that, I'm going to hand over to Mark, who's going to talk about the UK data reforms.